Appeals, First Appellate District of Ohio, with the Honorable Beth Meyer presiding. It's now in session. Please be seated.
Good morning. Welcome to the First District Court of Appeals. We have two cases on our docket to be argued, other cases on the docket, but have been submitted. The first case to be argued this morning is Dix Road Property versus Brown. Counsel, if you'll both approach.
Good morning, Your Honor. Joseph Matakovic here on behalf of Plaintiff Appellant Dix Road Property Management.
John Mulvey on behalf of the police, defendants, Susan Brown, and Stephen Prince.
Mr. Matakovic, you will have 15 minutes to argue this morning. Would you like to reserve any of that time?
Actually, Your Honors, I would like to reserve all of that time. I spoke with my colleague suggesting we could submit on the briefs, and he indicated that he wanted us to show up this morning, so I'm going to let him go first to see what he has to say.
All right. Before you do, I have a question for you, so maybe it won't be submitted on the briefs, perhaps. I mean, it might be submitted on the briefs, but I do have a question for you.
Okay.
Do we have a final order here? And the reason I ask, let me focus you in even further, that's kind of a broad question. There were objections to the magistrate's decision filed. Those were not ruled on, as I read the docket, prior to the notice of appeal being filed. Attempted to be dealt with at a later date, but do we have a final order?
I presume what happened was, and I don't spend a lot of time in Hamilton County Municipal Court with the electronic filing system. The magistrate issues the order and it gets filed and the 14-day clock starts to run. I e-file the objection, but I think the judge's decision adopting the magistrate's decision probably crossed in the ether with the objection. So I don't think the trial court knew that the objections had been filed, but there was a final appealable order that was issued. Then I filed the notice of appeal, and then at some point the trial court apparently realized that there had been an objection filed that it did not notice, and it sought to vacate its own judgment entry. I don't know that the court has the authority to do that, though, once the appeal is filed. So,
Well, and your objections, at least as I read the docket, were timely filed.
right. And I don't begrudge them the fact that it's a big court, there are a lot of cases. It's e-filing. I have no idea how it crosses a judge's desk. This was a landlord-tenant dispute. I presume a judge was assigned to it, but I don't know how closely the judges pay attention to until somebody puts something on their desk. And I just don't know how their electronic filing system puts it on their desk. So I don't begrudge them the fact that they missed it, but I felt kind of, my hands were tied. I had to file the notice of appeal lest I file something to ask them to set aside the judgment because they didn't consider the objections and they say no, and then I've run out of time somehow. And I didn't ask this court to remand the case to see what they were going to do with it. And my colleague did not either. So I think we're here today. I think we're properly here today. I don't know what Hamilton County Municipal Court was going to do.
And the reason you make that argument is because once the judge signed it, did she or he sign it before the objections were filed? Or can we tell by the time, the date stamp and the time?
I don't recall noticing dates or times on those things. I'm confident that the objections were filed within the 14 days. It seems to me that the final appealable order, or the decision signed off on by the trial judge at least, probably came within 2 or 3 days of that. I would not think that it would have been signed before it was filed, or signed before the objections were filed. But I can't tell you that off the top of my head.
Yeah, I think you filed your objections on November 10th, and the court didn't issue its entry until November 12th. So technically, they were filed prior to the final order being filed, and because a court speaks through its entries, you can see why we're raising this question.
Sure.
All right.
Absolutely.
Thank you. And Mr. Mulvey, I'm going to ask you the same question. Do we have a final appealable order in light of the discussion we just had? And if you'll step to the podium so we can have the microphone.
Make sure I wasn't abandoning something we might need.
You can always go back and get it.
Okay. Good morning.
Good morning.
I think I agree with Mr. Matakovic, but for different reasons. And I think timing is important. And in this situation, having had the opportunity to see the magistrate's decision, Mr. Matakovic timely filed his objections, but filed them in a manner that we would end up right before you as we are today. He filed the objections in a manner that he was objecting to the judgment itself on its face. He wasn't requesting a record. He didn't file a record. He made the arguments he was going to make, not knowing when the judge was going to sign off on it. So that, in essence, that's it. I think it's a important thing, the timing of the signing, the time of the filing, and no indication that the plaintiff would have filed any differently, notwithstanding the timing of the judge. And in this situation, under the statute and everything else, it seems to line up properly to me. But
All right. I think your colleague said he was going to wait and see if you argued anything on the merits, and he was reserving his time. I'm going to give you, if you want, 15 minutes to argue on the merits, or you can submit on the briefs that have been filed. Or take any of that 15 minutes.
I'll just take a few minutes.
All right.
And I think it's just that. I think the plaintiff created the record before this court, which is nothing. We have no indication of what the magistrate did or didn't take into consideration. We have no indication of whether the magistrate adopted an argument that we don't know whether it was made or not into the record. In this case, concerning interest, the record doesn't indicate if it was asked for, if it was calculated, or if some of the defendant's affirmative defenses may have applied. And again, this is just speculation because, again, I don't have a record to look at. It's possible, in part, either through equity or some of the affirmative defenses, or the very fact that the plaintiff is claiming that this is a suit on a sum certain, when in fact the plaintiff sued my clients for 23% more than the award was. So I don't see how you sit there and say that it's a calculable certain amount. And then I could get into, but it's not before this court, the reasons why that might have happened. I had my arguments. I don't know if the magistrate accepted any of them or none of them. Don't know. There was an issue of offset. I think there's an issue of equity, but I think the biggest thing, if I had to argue the facts, which I don't have anything before me to do that with, would be the fact that the plaintiff sued my client for a substantial amount more than the award and now seeks to get interest. I could go on with my theories, but I have nothing to look at to do anything other than just say that on its face, there's not enough information before this court to analyze whatever happened. That's it.
All right, thank you. Mr. Matakovic, would you like to take any of your 15 minutes that you have remaining?
Just briefly, Your Honor. I think the case law that I cited in my brief and my reply brief is clear. In a circumstance like this, I think it's understood. I think it's automatic. You understand that when a trial court grants a judgment, if they grant a judgment in an amount for the prevailing party, there's going to be interest that accrues on that. The question is just, what is that interest rate? And the statute clearly says it's the amount in the contract, and if there's no amount in the contract, then it's the legal rate. Looking at the court's paperwork...
If there's a contract that provides for it, or if there's a statute that provides for it, or if it's a sum certain.
Correct.
What about his argument that we don't know that because we don't have a transcript?
Well, you know, I don't think the issues that we've raised in the appeal hinge on a record or a transcript or any kind of testimony or anything.
Well, do we have the contract in our record?
Well, the contract was admitted as an exhibit at the hearing.
But
Now,
but we don't have the transcript from the hearing.
Well, but I presume that as part of the record, You have the hearing, the magistrate admits the evidence and things, and then she issues a decision. I presume that those things together become part of the record of the case file.
Only if you ask for it to be. Only if you ask for it to be transcribed, and the exhibits are part of that transcription. And as the appellant, you have the duty to make sure the record in front of us contains everything that you need it to.
Right.
And I don't know, I need to go back and double check whether, I don't think we have the contract as a part of our record.
Well, I did not file for any kind of transcript because, again, I think it's a legal issue, not a factual issue. The parties spent 2.5 hours in the courtroom having the hearing, and when it comes down to the legal issue of should there be judgment awarded on, should there be interest awarded as part of the judgment, again, I think that's a legal issue, and
But don't we have, excuse me for interrupting, but
You
I'm
get
going to come back.
That's your job.
Don't we need the contract to make that determination?
Well, again,
We can't just surmise that the contract provides for interest. We have
Right.
to see it.
Right. Well, and again, I presume that when it's admitted into evidence, it becomes part of the court's file. I presume that things that aren't admitted into evidence are not part of the court's file, so they would be part of the package that would come to this court. So the court would see those documents.
And if you're incorrect in your presumption and we don't have it as a part of our record, would you agree that we don't have any basis to award prejudgment interest?
Well, I guess you could say that, or you could say the paperwork that is the record, the magistrate's decision that was signed off on by the judge and adopted by the judge, is silent on the issue of interest. There's no mention of any interest at all, the statutory rate or the contract rate, and there's no mention of prejudgment versus post-judgment. So I think that issue can still be before the court if the court thinks, well, in the interest of completeness, we should have a transcript and what goes with the transcript, the actual identification and inclusion of the exhibits, then you might take the approach to say that the record is too thin. But I would suggest that given that the omission is apparent on the face of the document, this court could still say the trial court cannot be silent on the issue of interest, and it is true that the statute says and the other court decisions say it's the contract rate versus the statutory rate, and remand the case to say the trial court's decision is not clear, it's not complete, so we're going to send it back for them to say, you got to fill in that blank. And that's why I don't think it's an issue of transcript in the evidentiary part of the hearing. It's the legal argument that the entry just does not include interest, and it must include interest. So that's what I would say.
Well, it must include interest only if you establish that you're entitled to it.
Correct. And what I can tell you, and again, we don't have necessarily everything, whatever the court didn't put in its file, you don't have in front of you, but the court granted judgment. This was a dispute between a former landlord and the former tenants. There was a lease agreement that was introduced as an exhibit, and the magistrate granted judgment. So presumably there's a connection between the two. If that's not an inference this court is prepared to make, then again, I think you can remand it with the clarification that the court has to address that issue, that there can't be a blank on the judgment, that there can't be a missing piece in the judgment somehow, and then leave it to the trial court to say, okay, what did we get? What did we hear? And what did we or did we not do?
But that goes back then to the final order issue because you raised that in your objections that were never ruled on by the trial court.
Right. Well, and again, and like I said before, it was certainly possible that one of us could have asked you to remand the case to the trial court because the objection had not been heard, and it looks like some kind of clerical error. I didn't do that, Mr. Mulvey didn't do that, so we're here, but maybe that's an answer. Maybe the panel says, you know what, I think we're missing a piece of information here, and so we're going to remand it so that the court can do apparently what it realized it had not done, and then see how that outcome is before it actually comes before you for a final decision.
All right,
And I don't think
you.
I have anything else to add.
Any questions?
Thank you very much.
Thank you both very much. We will take this case under submission and give you a timely written opinion. Thank you. The next case on our docket this morning is BG Staffing versus Lance Soft. Mr. Fitzgerald is here for appellant. Mr. Cook is here for appellee.
Yes.
Mr. Fitzgerald, you will have 15 minutes to argue this morning. How much time would you like to reserve, if any?
If I could have 3 minutes, Your Honor.
You may, and I will keep your time and let you know when you're getting close.
Very good. Thank you very much. Good morning, and may it please the court. Again, Timothy Fitzgerald on behalf of the appellant Landsoft. We are here this morning in connection with an appeal from the trial court's denial of a 60B motion that resulted from an underlying default judgment against Landsoft in the amount of $145,000 plus interest for a number of years. There's also an issue that's been raised in this case as to whether or not the appeal is moot. There was execution and garnishment that took place during the course of the 60B hearing in the trial court. And BG Staffing has raised the issue of whether that, in fact, moots the appeal because there was a satisfaction of judgment filed in the trial court. I would submit that this is not a moot appeal. This is, again, a 60B motion. It is somewhat of an extraordinary case, however. It's not your typical 60B situation where you've got a defendant who is claiming that they were properly named in the case. But
Mr. Fitzgerald, I may interrupt you. Could you please focus in more on the mootness argument? Because looking at the timeline, it appears that there was no stay until October 2021, and that was after the judgment had already been satisfied, the funds had been dispersed, and the satisfaction of judgment had already been filed.
Yes, absolutely. That was where I was going to start. Thank you, Judge Bach. 3 reasons why I think that the issue is not moot at this point in time. The first is the argument is made that because there was no formal motion to stay the case under Rule 62, that in and of itself moots the appeal. I would submit that if you look at the underlying justification and purposes for seeking a stay in the case, it is to maintain a status quo in the case and or to provide the judgment creditor with security for the judgment in the event that either the 60B motion is denied or an appeal ultimately results in an affirmance of the judgment. There was security in this case. Security can be given by way of a bond or by way of the judgment debtor depositing money with the court sufficient to cover the judgment amount. Here what happened was, and it's very unique, the garnished funds were being held by the BG Staffing's attorney in his IOLTA account, somewhat by agreement of the parties, pending the ruling by the trial court on the 60B motion. Now,
But they were released.
Yes, they were, but they were by agreement of BG Staffing's trial lawyer. They were held in his IOLTA account despite the fact that they had been released. So the point is, I'm not suggesting that they needed to be held. What I'm suggesting is that from a belt and suspenders point of view, would it have been better if there had been a motion to stay filed in the trial court confirming that? I submit yes. But this is no different than if a plaintiff's attorney tells a defendant that he has an indefinite stay or extension to answer a complaint, and then at some point in time decides, you know what, you didn't answer the complaint, you haven't filed anything in the trial court to confirm that there is a leave to plead, and therefore takes a default judgment.
Where are the funds now?
They were dispersed by plaintiff's counsel, BG Staffing's attorney, 4 days after the trial court denied the 60B motion entirely.
So what relief could we give?
Well, I would submit that is not something that this court needs to necessarily address. It would be something that would need to be addressed on remand. If the funds...
We have to be able to give a remedy, or as Judge Bach suggests, the appeal is moot.
Well, what I would submit is that because the funds were being held, and we make this argument in our reply brief, that the BG Staffing should be equitably estopped from arguing that it's moot. They took steps that led Landsoft's trial lawyer to believe that the funds were being held. And again, that the purpose for those garnished funds being held was to give BG Staffing security that if the judgment was ultimately affirmed, that they would be able to recover the amount that was awarded to them.
But isn't the first district law very clear that once a judgment is satisfied, the appeal is moot? I mean, there was I know this because I was the trial judge on it, but there was what I call the Kenwood case, where the foreclosure happened and there was no bond posted, and the first district said it's moot. The judgment's been satisfied.
I think that I'm aware of those cases, and there are plenty from the first district as well as from across the state entirely. Those cases, for the most part, all rely upon the Supreme Court's decision in Blodgett. And I would submit a reading of the Blodgett case is very instructive in terms of what the Supreme Court meant when they said that if a judgment is paid or that it needs to be done voluntarily by the judgment debtor, the defendant in the case. And if you read the Blodgett case, it's a case that arose out of a divorce proceeding. And there were some funds that were being held in an escrow account. And the wife in the case wanted a disbursement of those funds pending her appeal. She apparently needed living expenses, and so it was ultimately agreed while her appeal was pending that there would be a disbursement from that escrow account of, I think, $2.7 million or something in that neighborhood. And in connection with that, she signed a satisfaction of judgment when she received the $2.7 million, but she wanted to proceed with her appeal. And the Supreme Court said, no, you can't do that. You voluntarily, and focused on the issue of voluntariness, you voluntarily signed that satisfaction of judgment. And because you did that, you have foregone the ability to pursue the appeal.
Haven't the subsequent cases extended that voluntariness to be the satisfaction of judgment when the appellant did not seek a stay of the execution of that judgment?
Well, I would submit that there needs to be some knowledge and or acquiescence that the funds are going to be dispersed without a stay. That's why I think this case is so different from all of those cases, whether it's Blodgett or the cases, the Wiest case that is cited by BG Staffing, and it's.
But couldn't we infer that there was an agreement based on the fact that there was no stay sought at that point?
I think you could. I think you could infer that there was an agreement between BG Staffing's attorney and Lansoft's trial lawyer that the funds would be held pending a disposition of the dispute that Lansoft. BG Staffing knew that Lansoft was disputing that it owed the money, and I think it's clear from the record that Lansoft does not owe this money. That's what makes this case so unique, and why the 60B motion is not like most 60B motions that you will see either in reported opinions or that you'll confront, where a defendant is arguing, I don't owe that much money, or I didn't run the red light. And obviously there's a dispute that as to whether, here there is no dispute that the party that is liable for the $145,000 in invoices that were unpaid, that's owed to BG Staffing. I will concede that the money is owed to BG Staffing. It's owed by a company called Zanet. And there is no connection between Lansoft and Zanet other than the fact that an officer of Zanet ultimately became an officer of Lansoft.
But doesn't that make it more important then that once the agent gets the summons, once the notice of default is there, once you know there's a judgment and you don't seek a stay, doesn't that all make it more important that your client take affirmative steps? Because that may well be true, that this is totally the wrong party.
As I said a moment ago, belt and suspenders, yes. Hindsight, 2020, I suppose so. But what we're here arguing today is this is a party that does not owe the funds. Judge Myers, as you indicated, it may very well be. And what's unique about this case is that the only issue in connection with the 60B motion is whether or not either 60B1 or 60B5 apply. The timeliness issue, and more importantly, whether or not Lansoft has a meritorious defense, has been stipulated to by BG Staffing. If you review the transcripts of the hearings, both of those elements of a 60B motion recall that there are 3 elements that you need approved for 60B relief, have been stipulated to. So BG Staffing recognizes that Landsoft certainly has a strong argument. They wouldn't even dispute it. They stipulated that based on the record and these invoices and statements that were all issued, the contract between Zanet and BG Staffing has nothing to do with Landsoft. Unlike KPMG, which, again, getting back into the kind of the prior, or early stages of this case, recall that the initial defendant named in this case was KPMG, the international consulting firm, because KPMG actually bought Zanet at some point in time. Now, they excluded certain, contracts because, and the one that we're talking about here today, the LA Metro project, created a conflict for KPMG, so they left that with the Zanet entity. But again, that in no way, shape, or form ever became an issue for Landsoft.
Could you talk to me about 60B1, excusable neglect? Because I didn't see much in your brief explaining how it could be neglect at all, much more, or how could, I'm sorry, I don't see anything showing any excusable neglect. Well,
again, it's based upon the confusion and the inaccuracy.
But it's my understanding that it was served on the agent, correct?
It was, yes.
Okay, and then your client, there appears to be some confusion about whether he actually got the summons and the complaint, but he most certainly got the default motion, correct?
Yes, at some point in time he did. That is correct.
Okay, so what I'm struggling to understand is how him completely ignoring it can rise to excusable neglect.
Well, it's not just excusable neglect in the sense that there needs to be a complete disregard for the judicial system. And, at the point in time when the default had been entered and garnishment proceedings had been commenced, there was action taken. So it was, the attorney for Landsoft, the corporate attorney, Mr. Varga, whose affidavit is in the record, immediately contacted BG Staffing's attorney, explained, much like the KPMG situation, where BG Staffing then backed away from pursuing KPMG, explained, hey, Landsoft is not the party that's liable here. And then, asked them to hold off doing anything further. That's the precursor to the agreement that they would hold the funds, the garnished funds, until the case was resolved. And ultimately, Ohio Council was engaged, and the 60B, the motion to vacate, was filed shortly after that, several months after the garnishment proceedings had begun. So it wasn't as if this was just a complete disregard for the proceedings.
Well, it was a complete disregard until they started trying to collect the money. So maybe not. I mean, I think an argument can be made that they disregarded it until they saw it was going to cost some money. And maybe they disregarded it because they said, we don't have any liability for this, so we don't need to defend it. But that's really not the legal test. And let me interrupt you because we have peppered you with questions and you're at your time if you want to reserve 3. But I'm going to let us finish our peppering and you'll still have 3 minutes left.
Thank you. Was there a question?
Yes, the question was, how do we deal with that? Isn't it, to Judge Bach's point, possible that there was inexcusable neglect until they tried to collect?
I would submit not in this case because it was known by Mr. Harkins that Zanet was the party that owed the money. Zanet was named as the entity. It was a DBA, but I would submit that a layperson who sees the name of Landsoft and then somehow Zanet is being named as well, that the proper party is being forced to pay the money. Zanet is being forced to pay the money, and that may have given comfort that nothing needs to be done. The proper party is going to be pursued. Admittedly, Zanet was out of business, probably would not be collectible, and I think that's what this case is about. This is a case searching for a party who can pay the judgment. That's why KPMG was initially named. BG Staffing must have known that Zanet was out of business. They were searching for somebody who could.
Is there
do it.
evidence of that on the record?
As to what?
That BG Staffing knew that Xannet was out of business?
I don't know if that specifically is in the record, but it's known that KPMG acquired, and that is in the record, that KPMG acquired Xannet in, I think it was June of 2014. And this project, this LA Metro project didn't even begin until 2017. So there needed to have been some interaction that would have led, BG Staffing to know what the status of Xannet was at the time. But to get back to and try to answer the question, if the 60B1 motion or appeal is not meritorious, there is a 60B5 aspect of the case. And I do think this is an extraordinary case. And I think you would be hard-pressed to find a case in which a court has allowed a party who is clearly not liable for a debt to be made responsible for 145, well, actually more than that because there's interest that's included. And that is separate and apart from the 60B1. So if the 60B1 is not successful, the 60B5 is grounds to reverse the trial court.
And you are past your time, but you will still have 3 minutes when you come
I
back.
appreciate that, Your Honor. I was going to ask if I could just have a brief moment on rebuttal, if you would.
You still have 3 minutes.
Oh, thank you very much.
Mr. Cook?
Thank you, Your Honor.
Can you start sort of where he left off? What do we do with the unusual situation where it does appear that his client has no liability for this debt?
That's not an accurate statement of the record. His client represented that they were Landsoft. We have an affidavit from our guy saying they made that representation. It was alleged in the amended complaint that they were doing business. Xannet was doing business as Landsoft. So I think, merely because there was a concession that there was a meritorious defense, that does not mean that there's any concession.
Your concession was there's merit. A court can hear this.
The court can hear it.
But we're not conceding that.
We did not concede anything. And really, if you look at the bottom line here, is the president, someone who was an official of Xantoff, on behalf of Landsoft, authorized services. There's no dispute the services were done for a period of time, and my client wasn't paid for them. It's really that simple. They performed services. The individual that was at Landsoft and then at Xannet, the president authorized these services. We have emails, so it is our position, that there is evidence that they may be responsible.
Right,
Let me ask you, sir, there was an implication, there was an agreement between counsel that funds would be held in the IOLTA account pending the resolution of this matter. What evidence is there of that?
I think there's very little evidence on the record, and I think we have to look at the timing. I think that's very important, because on July 1st, when Mr. Sander, trial counsel for BJ Staffing, was contacted, he informed the counsel for Landsoft that the garnishment would continue. He did not say, I'm going to stand. He said, we're going to move forward with the garnishment. And then 2 weeks passed, and then on July 16th, 2 weeks from that conversation with Landsoft's counsel that we're going to move forward, then the disbursement occurs. On August 4th, the judgment is satisfied. There's still no motion for stay. And then there's no motion to vacate filed till October 1st. And it was when the October 1st motion was filed that counsel decided at that point, when there's a motion to vacate, to just hold the money. So that had nothing to do with the garnishment, it had nothing to do with the disbursement of the money. And then once the 60B was overruled, the money was dispersed, and actually the last order by the trial court said that he found that the disbursement was proper. He did not find any agreement, and when there was a motion for stay made, and the trial judge actually it's attached to my brief because it somehow was at the end of the case and it didn't get in the docket. Where the trial judge says, there's nothing for me to stay. The funds have been dispersed, and I found the disbursement proper because I had overruled the 60B. So I think the timing is important, and I don't think there was an agreement. And the timing really relates to the garnishment, because that's the The failure to stay the garnishment is the voluntary act under this court's precedent and other precedent that results in the mootness. That no stay was made prior to the garnishment or the satisfaction. What happens after that, to me, is irrelevant. They didn't stay it before the garnishment, nor did they move to stay it before the satisfaction judgment was filed. Your Honor, in terms of excusable neglect, I think one thing that's sort of important to note is that we haven't really talked about is that this is an abuse of discretion standard of review. And many of the cases cited by the appellant, like the Sycamore case from this court, the court vacated the default judgment in that case. So that's a wholly different situation here. The case law is quite clear that the trial court gets a lot of deference in this area, and the trial court denied the 60B. And you can't find any abuse of discretion procedurally with what the trial court did. They had like 3 separate hearings on this. Time for discovery before overruling the motion. And all that needs to be shown is that there was a reasonable basis for the trial court's opinion. And I think there's a reasonable basis for several reasons. First, the Lansoff received, the amended complaint was received by Lansoff's statutory agent and then passed on by the statutory agent. Same thing with the motion for default. And as you recall, what the record really indicates is at the beginning of this whole process, the defendant swore up and down that they didn't get any of this. They never got any of it. And trial counsel for BJ Staffing subpoenaed the statutory agent because he said, well, that's kind of weird, They're usually statutory agents, that's what they do. They're usually pretty good about transmitting things because that's what they're in the business of doing. And when the statutory agent was submitted, it was proved that the amended complaint was received by the statutory agent and transmitted to Lansoff. And then we also have the decision maker at Lansoff admitting he received the motion for default judgment. But by far the largest fact in my mind is there's an admitted receipt of the motion for default judgment, and the motion for default judgment was filed, and 7 months go by before the motion is ruled on, and nothing is done. 7 months. We cited a case where I was involved involving a dental practice where the 5th District was very concerned that a period of 43 days was too much, was not excusable neglect. This is 7 months went on without anything being done. And at some point, even if there's some kind of problem with procedure, the neglect rises to the level of being inexcusable. You can't just ignore something forever.
So there was no memorandum in opposition filed to the motion for default, no notice of appearance, no.
Correct.
Just totally ignoring it for 7 months is your position.
Ignored until the garnishment started, basically. Until the garnishment was filed, and that's when the contact was made before the funds were dispersed, so the garnishment was ordered, but it was after the filing of the actual request for a garnishment, what I would call it. And the other thing in terms of excusable neglect is, as cited in our brief, most of the cases on excusable neglect require some kind of extraordinary or unusual circumstance. You can't just say, oh, we messed up. Somebody was ill. Somebody had an accident and was out of the office for a couple months. Things like that. Circumstances that are outside the control of the party that needs to respond. And there's been no evidence presented of any unusual or unordinary circumstances, which, I think the modern case law on excusable neglect, basically, it's almost a requirement. And in terms of I wanted to address the mootness issue just briefly. In addition to the failure to stay before the garnishment, I don't see, there's no equitable estoppel because there's no misrepresentation, nor is there any fraud. And actually, the trial judge actually said that in one of his opinions. I don't see any fraud here. There was certainly there's not even an allegation there was representation made before the garnishment, which means that is the whole, what happens after that garnishment and the judgment is satisfied doesn't mean anything. There was no request for stay prior to the garnished funds being diverted and prior to the entry of satisfaction being made. And there was certainly no grounds for equitable estoppel because there was no misrepresentation and no fraud. And if you don't have anything further,
Anything further?
thank you very much.
Thank you. Mr. Fitzgerald, you have 3 minutes remaining.
Thank you, Your Honor. I'm sure I won't be that long. The person who was overseeing Mr. Perkins' work at the LA Metro project was Mr. Harkins. He was the officer of Zanet. Yes, he supervised it, he authorized the work, he received the invoices. But it was at a time when he was not employed by Landsoft. He was doing consulting work for Landsoft in a separate capacity, but he was not authorizing the payment or overseeing Mr. Perkins' work while he was with Landsoft. So that's one point. On the issue of why there was no stay taken, recall that the trial court during one of the hearings indicated that in his view, even though the garnishment had taken place, even though the satisfaction of judgment had been filed, the judge at least gave some comfort that in his view, the case was not moot at that point in time. Now, again, should there have been something done, to confirm that in terms of writing?
Once it's paid, isn't the stay required before the judgment's satisfied?
The stay is only operational in terms of when the funds would be or some sort of security would be given to make sure that the judgment debtor was paid. So once the garnishment took place, at that point in time, the motion to stay would have only been emphasized in the sense that the money was available to BG Staffing. So the stay order would have been, again, belt and suspenders. But again, the inference, Judge Bach, I think as you indicated, that they held the money for a year is grounds to find that there was conduct by BG Staffing's lawyer that led Landsoft's trial lawyer to sit back and think that he didn't need to do anything.
But wasn't that pending the ruling on the Rule 60B? And so it was just, if anything, an agreement to hold it until the court decided whether it was going to vacate the default judgment.
It was obviously in connection with the default or the 60B motion. That is.
And once the court said, hey, I'm not going to vacate this default judgment, isn't it at that point that a stay should have been sought if you really thought it shouldn't be paid?
Well, and that's what prompted me to file the motion after I was engaged, but the funds had already been dispersed. But yeah, yes, again, belt and suspenders would have been, preferable, but that didn't happen here. I must concede that.
And I don't want to kind of beat a dead horse, but your colleague said something that got my attention. Give me your best argument. If it's true that 7 months passed from the admitted receipt of your client of the motion for default judgment and the ruling on it, give me your best argument on why that isn't an ignoring of the judicial system and inexcusable neglect.
I think it's based upon the fact that the party that truly was liable was identified as the party that was being pursued. Now, is a layperson going to differentiate between somebody that's or a motion that's naming Landsoft DBA Zanet as being somehow not pursuing Zanet? I submit not. I submit that a layperson is going to look at that and say, yes, Zanet is the party responsible and they're pursuing Zanet, and we don't have any grounds to challenge that because Zanet is liable. But Landsoft is not. And then finally...
so the default motion still named Landsoft.
It was the named defendant in the case. That is... But my point is that they're treating Landsoft and Zanet as two separate it's DBA Zanet Solutions Limited, so it's naming Zanet from a layperson's perspective, probably as a separately, identified, corporate entity, which it was. And so it was, at least could be viewed by a layperson that was what was happening, was that Zanet was going to be the one that was going to be found liable.
Thank you.
And you are at your time, but I'm going to let you finish that one thought. I think you were in the middle of a thought when I asked that question.
I was only going to add on the issue of the equitable estoppel. Mr. Cook indicated that it needs to be fraudulent misrepresentation. It's conduct. You can sit back quietly and do nothing, but if you're leading the other party to feel that they don't need to take action, that's enough to satisfy equitable estoppel, and that should be grounds for why this case is not moot. So with that, I would respectfully ask that the court reverse the trial court and remand this, because the party that's been hit with a $145,000 judgment is not liable for that money. Thank you.
I thank you. Counsel, thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion.
On appeal for appellate district of